8.
Right.
And he is only implicated in that particular matter.
Are you filing any reply? Liberty was granted?
As on, no. As on date, no. And I'll be seeking an extension, insofar as item, the person in,
Why, Mr. Bhattacharya? Because this was passed on the 2nd of May.
Undoubtedly. Now, I have to, I'm telling you, for your lordship, that at the outset, I'm telling, that the gentleman concerned, contempt number 8 is concerned, he has the highest regards for the judiciary, and he has not.
This is in CRLCP
7.
What is the name of your client?
Mr. Kunal Ghosh.
The others are not represented. The other alleged content. You are appearing for all the others, right?
All 7.
They are present in court.
Your opposition, those are ready. Why? If you let us hear, Mr. Bhattacharya.
Insofar as the contempt number 8 is concerned, whatever allegations for which he has been roped in the contempt, he was first of all not even there, on the date of incident. He was, giving a press, bite or something, there was a ETV program, somewhere in News 18 program, in Rajarhat, and at the material point of time when this incident complaint took place, he was not there.
That interview was given after or?
No, during
this incident.
No, that incident, on that particular day, for a different program altogether.
Yes, but
not related to this
after
program.
This or before this?
During this.
What about you? Why the delay?
Mr. Bhattacharya, whatever it is, you have to, we can't accept whatever you orally say from the bar.
I'll put an affidavit,
Why this delay? This is we are asking.
It is
2nd of May.
Yes, I tell you a lot. An affidavit was made ready. Incidentally, yesterday, since Mr. Chakraborty entered appearance on the previous day for the contempt number 8, from the Learned Advocate General's office, an email was circulated containing some report of the commissioner. It was circulated to us. It was circulated to us, so on going through it, it transpired that maybe some more time will be required just to come back to your lordship with my defense. But prima facie, your lordship may accept this, he was not even there fairly connected with the event.
Who is appearing for the, is the commissioner represented? Yes. Right.
This is the precise reason I told you, Lordship, on the other day, that a rule be issued, then everybody will come. If rule is not issued, extend the time, kindly extend the time.
My client is present in court.
No question of presence.
In regard to this, Raju Das and others, just now I have received this copy in which was served by the appellate side registers. I have obtained this Dhokalatnama.
PRLP 7 is my application. I am appearing. Apikaro appear. Then who is he appearing for?
Okay.
Represented today in number 7, you are for 127.
Problem. Mr. Mojumdar was given the impression that he is appearing for 127.
Yes.
Today
I am appearing on behalf of the CLP by 5, 6, and 7.
He is appearing for all the contempt notes.
All the contempt.
In 5, 6, and 7, all the contempt notes.
No, except 7, except Kunal Ghosh.
7 except Kunal Ghosh.
So,
Where is your letter of authority?
Dhokalatnama has been signed by them.
All of them.
All of them. May I
a person at serial number 8, he is personally present, and he He fought, irrespective of anything, he fought any of his conduct, any, contumacious act has taken.
Personal reason.
In any event,
He did not direct
as an
that.
abundant precaution, I advised him to be present in court because, in the event,
You have not filed the affidavit in opposition. So as of
for that reason, it is ready. I can show your lordship the what in my senior's language, but it is there. But I did not, I am not filing it only because of yesterday's affidavit was circulated and that too, quite late in the night. I mean, in the evening.
Lord, I told your lordship the other day that merely issuing a notice, they will come and say, kindly extend it, will only delay matters. So if a rule is issued, then my lord, they have to do it. So, my lord,
we take down
as of now, nothing has been controverted, but has been raised as facts.
Very well. Issue.
May I,
Yes.
one more thing, may I indicate, Milord? Mine is CRLP 7, Milord, where
7 where
seven
they are
is
all
the
appearing.
Bhattacharya, yes, Milord. But will kindly take one paragraph of the information that has been provided. That's paragraph 7, Milord.
Which
In the that was filed on the basis of which lordship was pleased to, Milord, initiate the contempt proceeding in CRLP 7, Milord. Paragraph 7, Milord. 7. Paragraph 7, lordship will kindly see, Milord.
Mr. Koshal, we are issuing rule against all
Deeply obliged, Milord.
because
Deeply obliged,
in
Milord.
spite of direction, affidavit has not been filed.
Deeply
So
obliged,
there
Milord.
is no explanation as of today on oath.
Deeply obliged, Milord.
Let them answer the rule. Issue.
And lordship will also kindly, Milord, take note of the link that has been provided, Milord. Let that link be, Milord, inspected, Milord. I had mentioned a link, Milord. There's a link that has been mentioned. A link has been quoted, Milord. Let that link also be decoded, Milord, if I may humbly submit, Milord. Press conference.
according to your allegation, Mr. Ghoshal, he sat with them.
Lordship, there's a link. Lordship will kindly take paragraph 7, Milord, once,
You
Milord.
stated that with
Yes.
above mentioned persons.
Yes, Milord. Precisely, Milord. That is my instructions, Milord.
So regarding those 16 other persons, let us go through the report first. On the next date, we'll do whatever is necessary.
Last chance, kindly extend the time by 3 days.
No.
We shall come back.
No, Mr. This is a very serious thing. We are not sending them to jail. We are not. Answer the rule. Issue.
Pursuant to your lordship's liberty, my lord, granted to us, my lord, we are filing the affidavit in opposition on behalf of Incorporated Law Society of Calcutta. Affidavit, my lord, on behalf of ILS, my lord, Incorporated Law Society.
Did we grant that liberty in the order?
Yes, on the last occasion.
Last portion of the order, lordship can.
Second last paragraph of the order.
All concerned. Yes.
Page
Yes.
27, my lord, paragraph 12.
ওদের দিয়েছেন কপি দিয়েছেন affidavit
And your lordship.
yes everything that anybody will file will be circulated amongst all appearing counsel. That is understood in this proceeding. There should be total transparency. We are directing circulation of the commissioner's report also so that everybody sees it. Yes.
Make this affidavit be, well, make this affidavit be,
Oh, very well, you have received.
and we shall circulate it.
Now near now
Leave may be granted to file the Bhokaratnama, in which
এখানে ফাইল করবে বকারত্তমা ডিপার্টমেন্ট
leave may be granted to file the department.
why should you require our leave?
Now, but half an hour.
Now to go and file it in course of the day. Yes.
My name will be recorded.
Oh, you have circulated it already. Oh, I see. So all of you have got the commissioner's report.
I submit very respectfully, the report, if I may use this expression, is hopeless in the sense he has given certain names. We have given 7 names. He has said we have, in fact, we said 16 names. Now, there is no whisper as to where this happened. Entire Kiran Road.
When did this happen?
When did this happen? Nothing mentioned. If you have got names of 16 persons, hundreds are there. Did you interrogate those 16 persons to get the names of others?
No.
Nothing mentioned. So, my full submission, this is done in a slipshod manner.
Their role in the in this thing has been indicated in the report.
Nothing.
Nothing.
Mr. Sengupta, allow us to consider the
Yes,
report and come by issue. Dekho. Report filed on behalf of the Commissioner of Police be kept with the records. Paragraph. Affidavit filed on behalf of Incorporated Law Society be also retained with the records. Paragraph. By our order dated May 2, 2025, we had recorded that prima facie we are satisfied of commission of criminal contempt by the alleged contemnors. Stop. We had granted liberty to the alleged contemnors to file their replies within a fortnight from the date of receipt of notice. Stop. Paragraph. Today, all the alleged contemnors are represented through learned advocates. Stop. None of them has filed any affidavit in response to the any affidavit. Stop. Paragraph. There will be a rule against the alleged contemnors. Stop. The rule is made returnable. Team, 2025. Mr. Lahiri, your junior will circulate the affidavit. Huh? Learned advocate representing the Incorporated Law Society is requested to circulate the affidavit filed today, amongst the other appearing advocates. Since the report of the Commissioner of Police has already been circulated amongst learned advocates, we do not pass any direction for circulating the same once again. Yes?
Only one submission.
Insofar as contender number 8 is concerned, he's seeking an extension and he will file the affidavit on the return. Kindly grant that leave.
What leave? We have issued a rule now. Answer the rule. Answer the rule. Right. June 16 at 12:30 p.m.
Only one accommodation, my lord. Whoever writes to us, my lord, whoever writes to us, we shall circulate. My lord, there are so many parties.
Yes.
It will not be possible for us to identify all of them.
ILS.
Whoever writes to that broken record of ILS, we shall circulate it.
Target sentence.
Whoever is willing to get a copy.
It's a paragraph করে লেখো। Requested to supply copies of the affidavit filed today to the learned advocates who request for the same.
Exception. If they don't show any cause.
কি সব একসঙ্গে করবো
No,
একসঙ্গেই হচ্ছে
different rule গুলো different ভাবে ফ্রেম করবে অর্ডারটা কমন হবে রুল গুলো আলাদা
কন্টেম্পটে এগুলো নেই।
ঠিক আছে
তিনটে আলাদা শিটে হবে
Already Basically, it was 16 June. But pastoral problem, but 16 June, the last data I will ruled in that.
See the number of learned lawyers appearing in this matter. Please, you have to come. Don't inconvenience everybody else. Be considerate. You are representing him. You are representing him. He's
24 আমাদেরকে
আমরা উঠে যাই? Huh? That is all for today, Mr. Senatto.
Enough.
My lord, I'm led by Mr. Dheeraj. Kindly give a short passover, my lord. Is coming, my lord.
Passover.
Item number 14.
হ্যাঁ, এবার এখনো জানেন না নাকি? না থাকলে তো পাস ওভারই হবে।
Item
বুঝিয়ে
number
দাও।
50. Item number
এটা কি
16.
সেকেন্ড কল হচ্ছে? এটা সেকেন্ড কল হচ্ছে? ও, এটা সেকেন্ড কল হচ্ছে।
Item 15.
14 এ কে ছিল? 14,
I'm praying for Passover. Mr.
14,
Yes,
14.
Your Lordship.
Very
Mr.
well, passed over. 15, 15 হয়ে গেছে। আচ্ছা, 16, 16 না, দাঁড়াও। সেকেন্ড কল তো। আচ্ছা, ঠিক আছে, একটু লিনিয়েন্ট হওয়া উচিত। পাস ওভার করে দাও।
Item number 17.
থার্ড কল করতে হবে, কেউ নেই। চলুন, সবই পাস ওভার।
Item number 18. Item number 19. Item number 21.
Upon the respondent, Your Lordship, on this one.
Item number 22. Item number 23 and to 25. Item number 26, 28. Okay, that's the check. Item number 29. Item number 30. Item number 31.
For the respondent.
Item number 32. Item number 33. Item number 34. Item number 35. Item number 36. Item number 37. Item number 38 and 39.
থার্ড কল।
13, right? Item number 13.
My lord, is coming on.
You are assisting him?
My lord.
You are here?
My lord, he will come, my lord.
দাও, এটা দাও দেখি।
Yes, may I start this because the maybe a message coming in 5 minutes may give some background. He'll be
Yes, we were thinking of reading the order.
yes, that's the message. He'll be here. I render unqualified apology. Rachit, this is my appeal, Milan. Oh, sorry.
Yes, Mr. Dave.
Lordship, we have challenged the order of the Honorable Single Judge. Very well. Very well, very well.
Now we will hear you.
If I have initial Millard, I render unqualified apology, Millard. Lordship, I have, as your Lordships have already gone through the Honorable Single Judge's order rejecting my application, what I could understand from the reading of that particular judgment, Millard, was this, that on 2 counts, basically, fraud will be proved on trial, 1. Secondly, that the plaint has to be rejected as a whole. It cannot be rejected as against me, qua against me. These are 2 pertinent points on which the Honorable Single Judge decided in against me. Now, my lord, there are other aspects also. Now, my lord, what has flown from what factual matrix is this, my lord, that in 2010, this property was sold in auction to me. I had nowhere in the plaint it has been stated apart from a pleading which is neither here nor there, that I, in collusion and connivance with the other defendants, specifically 3 and 4.
You are D1.
I am D1 because I am the auction purchaser. Now, my lord, I have purchased this property from a bank auction where admittedly the respondent number 2 in the plaint and here the respondent number 2 here also and before the in the suit also had taken a loan from respondent number 3. Now, this property was mortgaged with the respondent number 3, And it was
by the respondent number 2.
yes, and respondent number 2
Although
was
the
at that point.
property belonged to the respondent number 6.
No. As on that day, the property exclusively belonged to the respondent number 2 because he has purchased it in 1996 by 4 deeds of conveyance. So what happened was now I am going into the plaint. Let us go into the plaint because my learned senior friend may come up with this.
Only the plaint.
Only the plaint. What is in the plaint? Whether they have suppressed certain materials in the plaint also, that also I am taking in my stride because I cannot go beyond.
Now, paper boy to the.
Now, my lord, what is the case made? My lord, you kindly have the books. Have duto hi volume dita hai. Duto volume hai. My lords, the factual matrix of the case as pleaded by the plaintiff before the learned honorable single judge is that, my lord, the property which is in question belonged to respondent number 6, which is Chandan. Now, the plaintiff had only 7.97% shares de novo. How? Because one Gaylord.
Yes, Gaylord held that amalgamated with the plaintiff.
Amalgamated with the plaintiff, but that amalgamation took place way back in 1990. I'm coming. That thing took place way back, but then till the time the suit was. Notes do na. Ye notes. Dusra wala do. Lordship will kindly appreciate. Will give me.
March 94.
Yes, 1994, March 1994, it got amalgamated, but subsequently there too, they never got their names transferred in the share certificates of Chandan till 2016-17, which they have pleaded that when the company was struck off and when they did not get the balance sheet of Chandan for the financial year 2016-17, they could smell some problem. So then they made inquiries and they found that this property, that the company has been struck off, and then subsequently they came to know that the property which actually belonged to Chandan had been sold off in an auction by the DRT Delhi, and then after that they filed this suit. This is the case made out by them. Fraud in paragraph 40, subparagraph 12, the only thing which has been alleged against me is that I have purchased the property at a value which is grossly undervalued, the property which is tenanted admittedly in the plaint, and the main issue was that it is fully tenanted, they could not use it, therefore it was to be sold off, be that as it may, ought to have been sold off for 20 crores, as the value ought to have been in 2010.
How much you paid?
2 crores. Because that was, my lord, we are in the supplementary affidavit, since it has fallen from the honorable coordinate bench of this honorable court to file a supplementary affidavit.
Mr. Trivedi, that is strictly not relevant, even that. What value? What is relevant
Only
is
allegation against me.
What are
fraud.
the averments in the plaint?
That is what I'm saying. That is the only averment in the plaint against me. As far as Order 6, Rule 4 is concerned, is specifically pleading fraud. And what they are asking in the prayer, what you cannot do directly, you cannot do indirectly. They are asking for setting aside of sale, which cannot be done. It has to be done by the DRT, DR8. They have to go for setting it aside in section 20 or section 34. Rightly, wrongly, indifferently, I have purchased it from in auction. In 2010, sale was confirmed in 2011. Subsequently, a suit was filed in 2018 by a shareholder who was not even his name has not been there. And there are judgments of this honorable court, including the honorable Supreme Court, saying that you cannot claim that right if your name does not transpire. They did not even get their name. The share till date, the date of filing of the suit stood in the name of Gaylords, which have been annexed to the plaint. One more thing, Lordship, what I'm trying to impress with 7.97 shareholding. If for assumption's sake, tomorrow, if the major shareholders of the company wanted to sell off the property in 1996, majority rules, The only right which they have is under 241 to 246 of the Companies Act, being a minority shareholder. They did not do that. As far as 2014-15 plaintiff's balance sheet is concerned, on my reading of that particular balance sheet, it is nowhere mentioned that there is any tangible property standing in the name of the company on 2015-16, which they say that is the source of information which triggered off their belief that something wrong is going on, in order to bring in, to take out the limitation portion of it. Now, my lord, I will take, my lord, to my lord, the plaint itself. My lord kindly comes. Because what I have to rely is on the plaint, so my lord. The plaint starts, lordship, at page 30, but my lord, the relevant portions will start. Now, my lord, I will just take my lord through the array of parties at page 34. Ratnakar, my lord, lordships. Lordship will kindly see. Respondent number 1 happens to be myself.
Mr. Trivedi, let us try to cut it short. You would say, we presume, that without attacking the sale, they cannot get any relief. If they have to attack the sale, they have to go to DRT.
Yes,
the suit will not lie here. No proceeding. In a nutshell, this is what you would argue.
My lord, yes, basically that, my lord, but I have other icings of
Yes, they have sought for a declaration that the defendant number 1 has no right title interest.
Yes, other declarations are also there. If my lord kindly allows me.
That can only be allowed if
page 59, my lord, will kindly come.
The sale is invalidated.
My lord, there are other reliefs also, which are, my lord will kindly allow me to place before your lordships page 58, where the prayers began. If lordship may, a declaration that the defendant number 6 of the plaintiff is a shareholder is the absolute owner. Now, but how can they ask? They are only 6.7% shareholder. How declaration they can get? One. Secondly, lordship, handing over of vacant possession. It is fully tenanted. Ownership is with me. And the tenants are, and I will go through the plaint. They have specifically stated that it is a fully tenanted property.
You have got the property mutated in your name.
Lordship, I have to take instruction, but yes, my lord, I have, my lord, but off the cuff, I don't want to.
You are paying property tax.
Must be, my lord, 2,000.
Not must be.
My lord, I cannot, because this question, my lord, is falling from my lord. My lord, I have to take proper instruction, as my lord's officer, to come immaculately as to what is there, my lord. As of now, I don't have instructions, my lord, but I have a conscious belief, my lord, that they must have. But my lord, what I am trying to impress very humbly before my lord, that the property which is totally tenanted, they are wanting delivery of vacant possession, one, without making anybody. Then my lord will kindly allow me to come to the prayer. C. Declaration that the defendant number 1 has no right, title or interest. That is de novo setting aside that particular auction purchase. Then lordship, declaration that the defendant number 2 never acquired. That is not. Then my lord, G at page 60. Declaration that all sale, mortgage and or any other form of transfer of right, title and interest of the said property, being the premises number 201, 202, 203 Old China Bazaar Street, since the time when the defendant number 6 became the owner of the said property by way of registered deed in 1986 is null. How can that be done, my lord, in this suit when a DRT order is staring at the face? Then lordship, all documents of sale, mortgage, transfer of any right, title and interest in the said property so and so, since the defendant number 6 became the owner of the said property by a registered deed, adjudged, delivered and cancelled. Now, my lord, DRT's order has to be cancelled without DRT being a party. And it's an auction sale, my lord. The bank is involved. Then bank is involved. It was sold for valuable consideration in an auction. And later on, and they had because if my lord kindly takes, that is why the Honorable Coordinate Bench of my lords wanted me to file affidavit, supplementary affidavit, where I disclosed the entire pleading before the DRT, which was made way back in 2006, where it was specifically stated that the property belonged to respondent number 2 exclusively. Because it was, it was not very happily and specifically drafted that the property was sold in way before that.
Sold to
respondent number 2 by Chandan.
Is the conveyance available?
Yes, my lord.
It's on record.
My lord, it's not on record. We have craved leave. And we have given the details on supplementary affidavit.
Show us that conveyance.
My lord will
No.
kindly
Show us
come
the
to-
document.
My lord, then my lord will have to, because my lord, I apologize.
That's very important.
My lord, we have craved leave. As of now, my lord, I don't have, but then we have craved leave and we have given the specific numbers.
When did you affirm that affidavit?
My lord will come. Supplementary. February, lordship.
Today we are in May, towards the end of May. Your client still not has been able to.
No, my lord, we have the copy, my lord. As of today, my lord, client has not come, my lord. If my lord kindly tell me, we will bring it, my lord.
Bring it, bring it.
Asking for inspection of the document, they have not given it. Of the conveyance.
Bring it before us, we'll give you inspection. When?
Whenever my lord deems fit and proper.
Tomorrow?
My lord,
Old China Bazaar Street.
my lord, the documents, that is there with us, my lord.
Day after tomorrow?
Friday. Thursday फिर वहाँ फंसा होगा, फिर मुश्किल हो जाएगा. My lord, will it be my lord's pleasure to keep it on Thursday in the second half? Thursday on second half, my lord, I beseech my lord, because again I'll be cutting a sorry figure before your
No,
lordship
again,
tomorrow.
second half, first half, we can't predict, Mr. Trivedi. That is the
No, my
problem.
lord, I will be here, but because my lord, as
Let it come on Thursday, we'll
my
see.
lord,
that.
my lord.
Give us a copy on Wednesday, it will be very.
Yes, why don't you give them a copy? Give them a copy. Acha, dekho, issue.
My lord will record an order
Yes,
to that
yes,
effect.
we are recording an order. This appeal is directed against a judgment and order dated June 12, 2024, whereby a learned single judge of this court dismissed the application of the appellant, present appellant, for rejection of the plaint of the suit. Stop. Paragraph. It is the specific case of the appellant that the property in question was sold by
Well, we have pleaded in paragraph 6 of the supplementary affidavit.
the defendant number 6 in the suit to the defendant number 2 in the year
1996.
in the year 1996.
Particulars are given in that.
Stop. The defendant number 2 obtained loan from the defendant number 3 by mortgaging the said property. Stop. Since the defendant number 2 was unable to repay the loan, the property was put up for auction sale. Stop. The defendant number 1 purchased the property in such auction sale held by the Debts Recovery Tribunal, Delhi, Delhi. New Delhi or Delhi?
I suppose New Delhi. My lord, I'm just coming.
New
201 page. Just specifically.
Paragraph.
It is.
On the next date, the appellant shall produce.
It's Delhi only. New Delhi, lodge.
New Delhi.
New
produce. Original. A true copy of the conveyance deed whereby the property was sold by the defendant number 6 to the defendant number 2. Stop. A copy of such deed be also made available to learned advocate on record for the respondent number 1 oblique plaintiff by Wednesday date ta diye dao. Stop. Paragraph. List this matter on Thursday date ta diye dao.
I'm grateful. My lord, once again, unqualified apology.
No.
I'm running. My lord. Thank you.
Item number 14.
হ্যাঁ বাবা আমাকে এটা হেভি বকেছে 3 বার আমার নামে টাইম নিয়েছে বাবা আর না করতেই হবে
Common Order 12, Rule 6, my lord, which
Judgment about admission.
I have
Who's
been
application?
told other side vehemently opposed last 2 times time was taken on my
that never happened. I was not even here to oppose. My lord, I was humbly praying if this can stand over till after vacations, my lord. I mean, for long.
my lord, let me start it my lord otherwise my lord
It
point
will
is short
My lord,
If
that-
No,
you
if
start it, Mr. Chaudhary, kindly then complete because we'll forget
I'll
otherwise.
complete it
Then she has to do.
my lord, then I have to end my learner. He's with enough for
My
another party.
lordship will
He's
hear
leaving
the point
tomorrow also.
tomorrow it can be completed I'll finish by today
Ask her. Ask her.
He's leaving on his vacations already.
You are?
I'm not there tomorrow.
Who is for the plaintiff? You are for the plaintiff.
yes
I'm for the
Your order 7, rule 6 has been dismissed.
Order 12
my judgment upon admission has been dismissed. The short point is, my lord, the lessee has admitted that the lease has expired and they have surrendered. The under lessee is, we took out a judgment upon admission. Whole question is, my lord, the learned judge has not believed us or has dismissed the petition on the ground that fraud on under lessee has been pleaded. Therefore, these are triable issues, and there is one city civil court prior suit for declaration and with not being dispossessed without due process of law. On these two grounds, my application has been dismissed. So the short point that I will be arguing is that fraud on under lessee can only be a defense when the lease subsists. It's like this, my lord, I give a lease for 50 years, and my lord, the lessee inducts an under lessee, and my lord, for let us say after 25 years. So they have 25 and my lord, before expiry of that, my lord, if I enter into some sort of an arrangement with the lessee, my lord, the sub lessee can come and say it's a fraud on under lessee, the lease was there, you couldn't have surrendered before the time. But when my lord, all parties are admitting, and I shall show from the admission that they are also saying the lease had expired on a particular date, whether at all a fraud on under lessee can be, because there is no, it's not a triable issue. Fraud on under lessee is not a triable issue. That will be my humble submission. And the other aspect is, what is the effect of a prior suit which has an order of status quo? Can that prevent a court from passing an order of injunction, order of eviction, if otherwise I am entitled to? These are the 2 points involved.
Don't you have to get rid of that order of status quo?
No, my lord, with
Following due process of law.
order of status quo, my lord, status quo vis-a-vis a declaration suit where, my lord, these same people have sought a declaration that I am a tenant. And my lord, lordships have held, my lord, that eviction suit, my lord, it is the due process of law. My lord, what I am, my lord, that is why I am before your lordship. If I get a decree, it is the due process of law. So status quo in a declaration suit, it cannot prevent, my lord, it's not that. Otherwise, my lord, that status quo order will have an effect of section 42 of the Specific Relief Act. It is as if injuncting me from proceeding anywhere till I get that. That is not the law. So these are the 2 short points. And the admissions are in the affidavit. It is admitted that the lease had expired in 2015.
We are willing to hear you, but only if they are also willing to make submission.
That is.
Talk to them, because you complete your argument today and then they say we'll argue after vacation.
For one of
Completely useless because we'll forget everything.
my learned friend is leaving tomorrow on his
Not that.
then
I tell you, Lordship,
not a-
it took us a substantial time before the learned trial court will also to argue this point. The point which Mr. Chaudhary has rightly said, this one rider, if your Lordship rightly pointed out one thing.
না না করবে কিনা বলো ভাইয়া রাইডার দিয়ে লাভ
Take some
করবে তো
time.
বলো আমি শুরু করে
No,
দিচ্ছি
no, it may take. We don't mind if it takes time.
So what? Yes, চলো শুরু করে দিই তাহলে
I'll not be able to complete today, that's what I'm saying.
টুডে না টুমরো করে দিও পরশু করো
বেরিয়ে যাচ্ছে
তাহলে আবার গরম মারছে কেন?
বেরিয়ে যাচ্ছে
Ah, he's flying away.
টাইম চাও ভাই আমার ঘাড়ে বন্দুক রাখ
Flying away. এসো এসো করবে না জোর করে করিয়ে লাভ নেই। You are the underlessee.
Yes, I am one of the underlessee.
Another underlessee.
I am for defendant number 14. My learned friend, I missed.
13. Learned counsel for the defendant numbers 13 and 14. Pray for accommodation. Request for accommodation. paragraph list this matter once again. Give us a date. First week after reopening, 10th, June 10.
Item number 16.
আমাকে বদনাম দেবে না। For the appellant, Milord. Milord, eviction suit, Milord, decreed in our favor between the up to the Supreme Court. Between the period 2014 and 17, there was.
Who is opposing you?
Milord, Mr. Chaudhary. তুমি টাকা দেবে করবো না কেন? Between 2014 and 17, Milord, they were in occupation of the property, which is the period for which the mean profit was to be calculated. Milord, we gave evidence, Milord, that 100 rupees is the rate. We
Decree passed in 2014.
decree passed, Milord, in 16th of June 2015
By which court?
by this honorable court. And then it went to the division bench, and then it went to Supreme Court. And decree was affirmed. Chapter 13A decree. Special referee appointed by the learned single judge. Reference also started. For the first year and a half, nothing happened because matter was pending in Supreme Court, so nobody pursued. But after the Supreme Court judgment, Milord, we pursued. Ultimately, the report, Milord, came in 2021. In the report, Milord, we lost terribly. Milord, we wanted to prove 100 rupee. This is, Milord, a bungalow with adjoining, Milord, sheds, etc., used for commercial purpose by 17 point something kathas of land.
Where?
Hastings, Commissariat Road. Milord, we wanted to prove 100 rupees. Ultimately, Milord, the judgment is 51. My client said that enough is enough. I've got back possession. Let's put an end to the litigation. So, Milord, we said we'll accept that. But then the other side, Milord, ended up really challenging the decree. We want a quietus. We were
Challenging the decree?
challenging the special referee's report, Milord.
Award, huh?
So the award of the special referee, we applied for confirmation, they applied for setting aside, and ultimately, Milord, it was remanded back to the learned special referee by the learned judge. Against that order, we've come up in appeal. Kindly, Milord, have a look at the order, which is at page 502. The order is, Milord, dated 4th of October 23. I'll be, Milord, happy to walk out with the report confirmed because I don't want any litigation. So Milord, whatever is there, we want to, Milord, put an end to it. Otherwise, I had good reasons to challenge the report. I should actually be happy. I'm the one who lost before the learned referee.
Mr. Chaudhary, any chance of a...
No, Milord, because they are not interested to put in.
I don't
No,
think
I had.
so, because, my lord, we had tried it earlier also. The rates at which, my lord, my clients are proposing, they are not agreeable.
How much? 10 rupees?
No.
Eh?
In fact, my lord,
43.
the learned special referee has accepted the entire report of my valuer, disregarded the report of their valuer.
Yes.
But, my lord, in coming to a mid path, what he has done is, my lord, he has considered the valuation, the circle rate valuation of a period which is after the period, a future period. If the period is from 2014 to 2018, he has considered the valuation of 2019, and then he has back calculated it to arrive at that. That is
Yes,
not
relying on your witnesses' evidence that there is no
that
real
is-
change
that
in
is for the
valuation.
different purpose. We'll come to that, my lord. And that, my lord, the learned
And you
judge has accepted
he's-
it and said that you consider this. This is an anomaly.
But it's on.
If you want to avoid litigation, we are trying to work out a...
Yes.
What about 45? Will it be acceptable? Are you willing to go up to 45?
43
Whatever, well, I am bound by whatever my valuer.
No. Acha.
Whatever my valuer has given, my lord, I can't.
You are not bound by it.
There are 43
You
days.
can always offer 2 rupee more if you want to.
Take instruction.
Milord,
I'll
they
indicate-
suggested, Milord, 43.43. I suggested 100. The judgment is 51. Milord,
No, now 51 you said is acceptable to you.
it is acceptable.
We are asking how many more rupees you can come down and how many more rupees they can go up, so that if there is a meeting point,
Yes. Absolutely. Absolutely.
we want,
Falling from your lordship, my lord, we will take instruction. I also don't want to.
don't ask 45, you say till, and you can come down till what, you can go up till what. But it will help if you first tell us what is.
Milord, I have to without taking instructions, I will ask my client to agree. Milord, 51, Milord, kindly make it, Milord, 49 or 48, and I'll tell him that you just take it and finish. Take a demand draft, finish the litigation.
Ask your client for.
I'll ask him
48.
without taking instruction. I'm sure he's watching. Jigesh karo.
Yes, we will wait for a
Milord,
minute.
because he watches. And he sent me a message also that your matter is approaching and it's been passed over repeatedly because of your non-absence, because of your absence. Please go. I know him otherwise.
You also, why don't you ask your junior to go out and.
Milord, now the whole, if I may use the expression, the whole game has changed.
Yes.
The client knows exactly what is happening, which is good. It's
I am not in favor of YouTube.
also obviously the change stand public
So far as, my lord, online it is all right, but not YouTube for the public at large to see.
You mean live streaming on YouTube?
Because, my lord, it remains, it creates problems later.
Milord, to be very honest, I don't, Milord, usually on all serious issues, I agree with Mr. Chaudhary. It's only, Milord, the non-serious ones that I disagree. But here I am disagreeing because this creates a lot of transparency.
But there are problems also.
Transparency, all right, my lord, lawyers having access to, my lord, the virtual recording.
It's good for the clients.
It is all right.
Good for the clients. They see what's happening.
Public at large viewing court proceedings in YouTube, either, my lord, live streaming or otherwise, referred or recorded. But I don't think it's a good idea.
There are some people, some regular litigants who have become very fond of watching court proceedings. So, they say that even if they don't have a litigation, and if there's nothing to do in office, they sometimes switch to a courtroom, log into a courtroom and watch. We leave it to your lordship.
Nah,
and we'll
that we can't do. Then we'll
leave it to
decide
your
on
lordship
merits.
and we'll accept it, Milord.
Then we'll.
Milord, I have said
Yes,
49.
let his
Your
junior come
lordship
back.
will, Milord, decide whether it should be 49, whether it should be slightly lower. Milord, we leave it to your
Mr.
lordship.
Chaudhary,
We'll agree.
we don't have that expertise. We don't deal in properties. We are just trying to.
No. Milord, when one party is saying 43 and the other.
Saying that since it's falling, 43 was there, up to 45, but, my lord, some installments can be given.
Very well, Milord, may I just say this? He's come up to 45. My client, Milord, has been pushed down by me to 49. Let's make it 47 in the middle and finish it for all times to come.
We can't force either of you to do
No,
that.
I'm requesting Mr. Chaudhary to agree.
I have to take
Take
instruction.
instruction.
now.
Take instruction.
Take
Finish it off. Say that it's going to end here and now.
End here and now, finished.
46 se Rajiv hai ja.
So if you can agree to 47,
Arey,
fairness
abhi
should
to-
propel you to agree. A person like you should agree. That is agreeable.
This is also on YouTube.
47, Milord, I think it's fair.
Up to you. Don't look at us.
Hey, Vadi Bhai.
No, he is saying
Baba ke
beyond that, the board of directors.
No.
Keep it.
Milord,
But
47,
kindly day after,
I'll get Mr. Sharma to agree.
Yes.
I'll call him up in the
Yes, day after
because
tomorrow.
one director singularly cannot take that
Correct.
decision. Kindly keep it.
Ashok, the appellant has obtained an eviction decree which he has sustained till the Honorable Supreme Court. Stop. paragraph, the learned suit court had appointed a special referee to determine the quantum of mean profits. Stop. The special referee published an award directing the respondent oblique defendant to pay mean profits at the rate of rupees 51.50 per square feet. Stop. The appellant applied for confirmation of the report. Stop. The respondent challenged the report. Stop. By the order impugned, paragraph by the order impugned, comma, the report has been set aside. Stop. Hence, this appeal at the instance of the decree holder, oblique plaintiff, paragraph, there may be a chance of settlement between the parties on the point of the rate at which mean profits should be paid. Stop. On the request made by learned counsel for the parties, comma, we adjourn this matter and direct it to be listed again on, when you said?
May I request for tomorrow 2 p.m. if it's possible? There'll be some certainty to the whole thing.
We can.
আমি কথা বলবো কমলদার সঙ্গে।
But if you don't, we will not be hearing it at 2 p.m. If you can settle, we'll record
Day
that.
after tomorrow.
Day after tomorrow.
Because I want to finish it off.
Come back Wednesday.
না না আমি তো রাজি আছি। তুমি তো টর্মেন্ট করছো আমায়।
Item 17.
Hey, day after tomorrow, first appeal from order. Let this be the first item under the heading appeal from orders. Day after tomorrow. As the first, as the first item. List the matter on such and such as the first item under the heading appeal from orders. লেখার দরকার নেই, বলে দিয়েছি তো।
My lord, I appear for the appellant, my lord, in
I'm
this
appearing
matter.
for the respondent number 1.
Well, this appeal arises out of an order of 18th September.
You appear for all the respondents.
I'm appearing for respondent number 1, your lordship.
My lord, it's only the first respondent who was contesting before the trial court also. And
So you have not even served the respondent number 2.
No, others have been served.
Served.
Yes. But my lord, this matter was adjourned from time to time only on the ground that parties were, my lord, trying to, my lord, settle. Now, my lord, I have instructions that, my lord, it is no longer, my lord.
Settlement has failed.
Settlement has failed. But, my lord, this is otherwise ready for hearing. I would request your lordship to keep it immediately after, my lord, reopening, and lordship may take
What, eviction again? No.
No, not eviction, my lord. This is, my lord, in respect of a property at Theatre Road. There was an original suit filed by the developer, my learned friend's client, seeking specific performance, where my client had, my lord, agreed to, my lord, let go of the property, take 1050 square feet of commercial space, and, my lord, a car parking in that Theatre Road property. My lord, lordship may have noticed, my lord, coming up like Orbit Bella. That's the, my lord, name of the property, the project which is coming up.
I sleep in the car when I travel.
So, my lord, this is the issue, my lord. Today, my lord, there was a decree passed in that suit. The decree, my lord, specified the manner of distribution. They are acting contrary to that.
Learned advocate for the appellant says that parties were trying to settle the matter out of court. Stop. However, that has failed. Stop. Paragraph as requested, comma, let this matter stand adjourned and be listed again on June 11.
Item number 18.
Yes, Mr. Kaur.
I appear for the appellant, my lord, but yes, my learned friend is here.
Let us take it up then. You want to do it now?
Yes, my lord. So date side, I have a copy check. দেখো তো list of dates বার কর। Lord, this is an appeal from dismissal of my application under Chapter 13A for possession. এইরকম list of dates আছে। Lord, I feel it will be convenient for your lordship to have the list of dates, my lord. Lord, may I place the list of dates first, my lord? It will be convenient for your lordship. On 7th August 1936, a lease for 50 years was given to Meters Limited in respect of 8 Lions Range with an option for renewal for a further term of 30 years. Lease commenced from 1st Bhadro 1343 BS corresponding to 17th August and expired on 16th August 1986. Renewal period expired on 16th August 2016. Thereafter a mortgage. Now, my lord, I will take your lordship to the interim arrangements, and then on 4th May 1959, your lordship will find at page 2, fourth item. There is a deed of partition of properties between Jagannath Rai and Balaram Rai, including leasehold interest of premises number 8 Lions Range, Calcutta. Original document is in custody of Balaram Rai. The property subsequently renumbered at 8 Lions Range and 16 India Exchange Place. Well, originally it was 8. There were 2 properties. They were subsequently renumbered as 8 and 16. Then 27th July, attachment made by the Income Tax Officer C Ward under Section 226(3) of the Income Tax Act for alleged dues of Uday Chand Mahata. Then 30th May 1978, letter from Ramakrishna Mission, who are the subsequent assignee of the lease of 16 India Exchange Place.
Ramakrishna Mission, the Belur Mission is involved in this matter.
They are no longer involved in this matter.
Are you sure, Mr. Kaur?
Absolutely, my lord. Otherwise, I would not have said so.
All right.
I would not have said so. Letter from Ramakrishna Mission to Income Tax Officer that amount of rupees 3,400 has been deposited for the month of Poush, Magh and Phalgun and Chaitra 1384 BF. Lord, why I am saying so? I had filed an earlier suit in respect of the lease. I had to withdraw this when I came to know of this payment. And then I gave a notice under 106 of the Transfer of Property Act and filed the second suit. This is why this has become relevant. Then again, 14th April, intimating, Ramakrishna Mission intimating that rent has been paid in respect of 16 India Exchange Place for 7 months. Then 2nd January 1984, again another payment. Then original period of lease expired. Then 25th February 1997, letter from Tax Recovery Officer, Calcutta 24-2, Shodai Chand Mahatab, being the legal heir of UC Mahatab, inter alia that premises number 8 Lions Range and 16 India Exchange Place have been released from attachment. My lord, this will be relevant because I could not take any steps in the meantime during the attachment. Then, my lord, 13th May 2004, letter from Mrs. R.C. Kaur for appellant to Srimati Annapurna Roy, predecessor in interest of defendant number 1A and 1B, that the tenancy is holding over the aforesaid premises of the original lease, and the notice was issued under Section 106 of the Transfer of Property Act. I'll place this letter and the reply thereto. Then 13 June 2004, letter from Kanak Narayan Ganguly, advocate on behalf of Annapurna Rai, inter alia stating that his client is in occupation of the aforesaid building by virtue of a registered deed of lease dated 7th August 1936 for a period of 50 years with an option for renewal for further period. Then 29th March, the present suit filed, and Millard, one date is missing there, 27th April 2012. Earlier suit was dismissed. Earlier suit file was dismissed when none of the parties were present before the court.
What is the date?
27th of June 2012. Milan, I'm sorry, 27th of April.
Dismissed for default.
Earlier suit.
Dismissed for default.
Dismissed for default, none appeared. Because it is being claimed that, I'll come to that later. Then 27th, as none appeared before the court. 27 November 2018, defendant number 1A was served of summons in this suit. Then 10 December 2018, then the defendant number 1A entered appearance. Then 12 December 2018, defendant number 1B was served. Then 19th December, defendant number 1B entered appearance. 5th February 2019, application under chapter 13A taken out. Then 21st of February 2019, written statement filed by defendant number 1A and 1B. Then 30th September, affidavit in opposition by David Rai, affidavit in reply on 1st November, and judgment of the trial court. My Lord, my first submission is that the application could not have been dismissed on facts. Why I say so, if your Lordship will kindly take the judgment. Judgment is at page 154, part 2.
No, Ramakrishna Mission is a party, Mr. Kaur.
They are no longer in the property. They have also assigned it to somebody else.
You nominee, they are parties to the suit.
Parties to the suit.
I touch nothing where Ramakrishna Mission is there. Sorry. This is why I asked at the very beginning.
My Lord, presently they are not
Absolutely.
involved.
No. It's enough that they are, it's different number 3.
Different number 3.
We are not inclined to take up this matter on the personal ground of one of us, Amar Namta Diyada. Paragraph. Let the matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. Sorry, Mr. Kaur. I'm deeply involved with them.
I can't help it.
Banking advisor.
Well, list of days গুলো ফেরত দিয়ে দেবেন এগুলো নেক্সট জজের কাছে দিতে হবে হ্যাঁ রেখে তোকে আর দুবার দেবো না
19
কেউ ছিল আগে third call usual order
Article 21
ছিল usual order
Article 22
22
Shatarup Banerjee is my leader, my lord. I think he's on his way, my lord. This is a appeal against my lord rejection of the execution of a compromise decree. the suit for eviction against the tenant of 1996, and then the compromise has been executed by both of the parties. And the decree was, my lord, the terms of settlement was that the suit premises initially was 2,000 square feet. That has been 500 square feet has been surrendered by the.
Show us the terms of settlement.
Yes,
Very
madam.
simple. Let us see. See. What call it?
No, decree is from page.
Nobody appeared for the appellant, either in the first call or in the second call. No accommodation was sought for. Paragraph. In the third call also, nobody appears. Stop. Nobody appeared, whatever it is. So entry order.
না পেপার করতে হবে হলো না কনসিড করো
Your leader has come.
yes
দেখেছিস বলেছিস কিছু? This is my lord the appeal. My lord the execution proceeding was my lord dismissed of my lord a decree passed my lord in a settlement agreement, in terms of a settlement agreement. One of the issue involved is that my lord there was an eviction suit in which a settlement was arrived at.
Jaspal was the landlord.
Yes. My lord, an eviction suit in which a settlement was arrived at. The settlement was of this kind that, my lord, the area in which, my lord, eviction was sought for, the same area was given to him. Only that, my lord, the portion, my lord, was little, my lord, less in, my lord. My lord, let us take it was 100 square feet, it was made 80 square feet. Oh, I'm giving an example. So 100 square feet, my lord, let us take, my lord, it was made 80 square feet. And my lord, he was to vacate this premises after a period of, my lord, say 10 years. And he used to pay rent. And there was, my lord, a noting in that settlement that, my lord, if there is a violation in terms of the Premises Tenancy Act, the terms in the Premises Tenancy Act, then I would be entitled to execute the decree. This was the language. My lord, he violated by non-paying the, my lord, rents. We file the proceeding for execution. When we file the proceeding for execution, the respondent or, my lord, the judgment debtor comes before the court and says that the execution per se is not maintainable. Although against the same decree, he had earlier filed an execution and obtained orders. Same decree. Now he says the decree is not executable because you have to now again file proceedings under the, my lord, eviction laws and evict me. Now, my lord, the two most important issues are, one is that, my lord, this is nowhere spelled out in his affidavit, which was called for by the, my lord, executing court. Nowhere. A complete submission from the bar. Secondly, my lord, is that, my lord, the terms itself says that I can execute the decree. I don't have to go, my lord, under the rigors of the Eviction Act again, my lord, and, my lord, file a proceeding and wait for 20 years for, my lord, eviction. Thirdly, most important, my lord, is that by efflux of time, as it is, my lord, the term has come to an end. Today, as it is by efflux of time, which was there in the decree, that time is over. So he needs to vacate the premises, my lord. So these, my lord, are the, my lord, three counts on which lordship has to adjudicate this appeal, my lord. My lord, the paper book to file.
The paper book was not called for because, my lord, I think, my lord, this is an issue which can be, my lord, considered by my lord and can be disposed of.
Have you annexed all the relevant papers to
Everything
the
is there.
stay petition?
Yes, everything is there. In fact, my lord,
Treat
Justice
that.
Sen has heard for a period, and then, my lord, he my lord, raised this issue also to them as to now why should we go into the merits when the time has already come to an end. As it is, you need to leave the premises. We need not look into the, my lord, nitty-gritty of law or, my lord, the questions which are involved now. So, my lord, it is ready any day lordship pleases, I can, my lord, do.
Tell us when.
Any on the reopening date,
Reopening date?
9th only, my lord.
This
Everything is there, my lord. In fact, we have filed a notes also. No? Notes also have been filed by both the parties, I think.
This appeal is directed against a judgment and order dated May 3, 2024, whereby the appellant's execution application being EC number 364 of 2021 has been dismissed by a learned judge of this court. Stop. Paragraph. Learned advocate for the appellant oblique plaintiff says that all relevant papers have been annexed to the stay petition filed in this appeal. Stop. The appeal.
And, my lord, notes have also been filed by both the parties.
Stop. The appeal can be disposed of on the basis of the stay petition. Stop. Notes of argument have also been filed by the parties. Paragraph. We shall hear out the appeal, treating the stay petition as an informal paper book. Stop. All formalities are dispensed with. Stop. Since the respondent is represented, notice of appeal is deemed to be waived. Paragraph lists the matter on June 9.
9th only. Grateful.
2025. Yes, if the period has expired, then what, Mr. Kaur?
The only contention we had made, they had said we were not paying rent.
Forget about that. Now that the period is gone by a flux of time, take instruction what remains. Taking a cue from the coordinate bench.
The only submission made by us was that it was a fresh induction. It was not in discharge of execution of a decree.
Fresh induction was accepted by the learned single judge. This point.
Yes, that is what
Yes.
was argued. my lord.
It was a fresh induction, fresh creation of tenancy, and I cannot be evicted without due process of law by way of an execution proceeding.
Fresh tenants.
সেটাও যদি হয় তাও তো টাইমটা ওভার হয়ে যাবে।
Yes.
Great. Number, item number 22.
Well,
Yes, Mr. Sen.
the previous matter, well, I was waiting here. Well,
Which
just
one?
Item number 21.
21. Call 21. My court officer was right that it will be mentioned immediately.
No, I was waiting. Well,
Who is on your other side? Call 21. 21 to Corona.
this arises from a execution proceeding, Millard. Canara Bank was the lessee under my learned friend's client. Millard, suit for eviction. A terms of settlement was filed. Well, in terms of the terms of settlement, Millard, we were to pay 50% of the municipal rates and taxes, which was to be assessed. Now, the dispute here is only with regard to our obligation with regard to the municipal rates and taxes. And the service charge aspect, that ballot has been discharged, obligation has been discharged. Executing court ballot, on the basis of their tabular statement, crystallized an amount of 62 lakhs odd.
Who executed the decree?
My learned friend's client.
Consent decree.
Yes, on the basis of the term with regard to payment of the municipal rates and taxes. We had preferred an appeal from that, my lord. The appellate court set aside that order of the executing court, direct saying that that calculation which was they had made was not in terms of the terms of settlement. The area under our occupation, what is the property tax assessed by Kolkata Municipal Corporation in respect of the area under occupation has to be assessed first. On that assessment, our liability is restricted to 50%. So that exercise was not done before the executing court when they had filed the tabular statement. So, my lord, the division bench, keeping the appeal pending, directed the corporation to make an assessment first. So, my lord, corporation made that assessment, and on the basis of that, the division bench disposed of that appeal. Now, my lord, they filed a writ petition challenging that assessment. We calculated, we were also there before the writ court. We said that we will pay 50% of the assessed amount done by the Kolkata Municipal. Based on that, my lord, we have paid it to the Kolkata Municipal Corporation. Admittedly, there is a receipt of that. My learned friends thereafter filed execution again for recovery of the amount. Before the executing court, it was our case specifically.
This round of litigation.
Yes, this round of that we have paid, and it is liberty was given to us by the writ court. We have paid to the corporation. That should be recorded as satisfied, subject to the writ court their challenge to the assessment being determined. For the time being, whatever is the assessment, 50% of our liability have already been paid. Now, the learned judge in the executing court, my lord, considered that whatever calculations they have given is not proper, considered that we have paid in terms of the liberty granted by the writ court, but said that we were under an obligation to obtain leave of the executing court, and we must pay again that amount. So it's becoming a case of double payment. Assessment made by Kolkata Municipal Corporation, they might have challenged. There is no stay on that assessment. Liability has accrued. To discharge my liability, I have made that payment to Kolkata Municipal Corporation. It may be that I could have come to the executing court also and have sought for leave and to make the payment. But the fact remains that payment has been made to Kolkata Municipal Corporation, and that is to their credit. So, my lord, why should I be liable to make again payment to them? That is the only issue, my lord, which is involved here. My lord, if I may just show your lordship the impugned order. Before that, my lord, I show your lordship the first order of the division bench, by which the corporation was first execution order was set aside and corporation was directed to make the assessment. Page 151. Kindly come to page 151. This is the order dated January 8, 2020. It is at page 83 of the paper book. 83 to Kindly come to 84. I'll place the relevant parts only, my lord. I'll need not go through the entirety. Kindly come to page 84, third paragraph. These two appeals arise out of the orders dated January 8, 2019, July 10, 2019, passed in execution. There is no dispute as to entitlement of the respondent lesser. Terms of settlement executed in appeal between the parties clearly provide for the respondent herein being entitled to 50% of municipal tax, 100% of surcharge allowance in respect of tenanted portion for the period from such and such. Terms of settlement contemplated the appellant bank to continue in occupation of the premises in question till March 31 and provided for lease rent at the rate of such and such. It is undisputed position that on or by or about September 30, appellant bank removed itself from the premises in question. Thus, the liability of the bank to pay rent and municipal tax and surcharge in respect of the leasehold premises was till the end of September 2011. The execution case came to be launched upon the bank not paying its share of municipal tax and surcharge, notwithstanding the terms of settlement of August 3, 2016, specifically requiring the bank to bear 50% of the municipal tax and the entirety of the surcharge. Then, my lord, your lordship will come kindly. Page 85, second paragraph. It is evident from the records that the amount claimed to be due in the tabular statement filed by the respondent herein was not supported by requisite calculation in the affidavit accompanying the tabular statement. Supplementary affidavit came to be filed by the respondent in January 17, which indicated a different basis. Further supplementary affidavit was filed in March 2017, and further supplementary affidavit gave another figure as the amount due and owing from the appellant herein to the respondent on account of municipal tax and surcharge. For completeness, it is necessary to record that the executing court appointed a special referee and objections were taken to the special referee's method of calculating the quantum payable by the appellant on account of municipal tax. Ultimately, both the court and the parties ignored the special referee's report, proceeded on the basis of calculations furnished by the respondent and the response thereto by the appellant. By order dated June 13, executing court held in an affidavit filed by the appellant herein, it was admitted that a sum of 26 lakhs such and such was payable towards municipal tax. On such perception that the amount was admitted, the appellant was directed to make payment of such amount without prejudice to the respondent decree holder's claim that a much larger amount was due. Then that order was carried in appeal. Appellate court observed that since the order was based on the statement of the appellant, the order could not be appealed against. However, while disposing of the appeal, the following was said in the appellate order. Accordingly, IPO number such and such is dismissed without going into the merits thereof, and by leaving the appellant free to take what steps as may be available to the appellant if the appellant perceives a calculation or arithmetical mistake to have been made in arriving at the aforesaid figure. So based on this, the appellate court held that I did not admit anything. And then, my lord, kindly comes to the 87, the relevant part. Last paragraph, 87. Starts with what is apparent from the terms of settlement of August 3, 2016 is that appellant herein was liable to pay municipal tax at the rate of 50% in respect of the area occupied by the appellant at the relevant premises and the entirety of the surcharge relatable to the area. On the other hand, in one of the earlier claims relied upon by the lessor in its execution application, it sought to make the appellant lessee liable for 2/3 of the proportionate amount, despite the clear use of the figure 50% in the terms of settlement of August 3. Even later, particularly in the supplementary affidavits filed by the lessor in January 17 and March 17, the lessor tried to interpret proportionate with reference to quantum of rent paid by the appellant against the total quantum of rent received for the entirety of the premises in question. Clearly, this was contrary to the terms of settlement, since such terms provided for the area occupied by the appellant herein and indicated that proportionate 50% of municipal taxes and 100% of surcharge would be paid by the appellant herein. Thus, if municipal taxes are assessed in respect of the premises in question in its entirety, the area under occupation of the appellant would be the basis for determining the proportion of the municipal tax and surcharge that the appellant would be liable to pay for the entire period. In such context, appellant refers to 178 of the Kolkata Municipal Corporation Act and says that subsection 6 thereof permits both an owner and a lessee in respect of any premises to apply to the corporation for the corporation to indicate the proportionate share of the relevant party regarding the municipal rates. In view of such provisions, the parties are left to apply to the corporation for the corporation to determine what would be the proportionate share of municipal taxes and surcharge for the area at the premises under occupation of the appellant during the period April 2006 to September 2011. Upon such determination being arrived at, appellant will be liable to pay 50% of the municipal tax and full complement of the surcharge that is indicated by the corporation, subject to the right that both the appellant and respondent may have to apply to the corporation for correction of any error perceived to have been made in the relevant determination. Let this appeal now appear. So thereafter, my lord, Kindly come to the assess report of the Kolkata Municipal Corporation in terms of this direction. It was assessed. Kindly come to page 143. This was the report of the assessor. Kindly take the relevant part, my lord, at page 144. After the table, the total liability of property tax and surcharge as per terms of settlement for the portion occupied by Canara Bank. My lord has got it. Canara Bank from April 2006 to September 2011 is as under. Total property tax liability of Canara Bank is such and such. Total surcharge liability of Canara Bank for the occupied portion. So total liability of Canara Bank is given, my lord, 1,51,00,000. So based on this assessment, my lord, the appeal court disposed of the earlier appeal. That order is at page 90. This report was placed and the division bench disposed of the earlier appeal. 30th of September. The Kolkata Municipal Corporation has filed 2 reports by way of an affidavit and a supplementary affidavit in terms, page 90. And supplementary affidavit in terms of the order of the division bench dated 8th January 2020. Mr. Such and such learned advocate appearing for the respondent submits that corporation has transgressed the area demarcated to it by this order. It was only required to determine respective shares of the parties in municipal tax payable in respect of the subject property. It was not entrusted with making a revised valuation of the premises. He says the valuation aspect will be taken up by his clients in an appropriate jurisdiction. Be that as it may, subject decree as modified in appeal remains unexecuted. We admit the appeal dispensing with other formalities and dispose of the same with the direction that respondent will be at liberty to take out a fresh application before the executing court to execute the decree dated 31st July 2008, which was subsequently modified by the decree passed by the division bench on 4th August 2010 in accordance with the terms of settlement executed between the parties on 3rd August. While considering the, kindly note this word, while considering the execution application, executing court will take into account the order of the division bench dated 8th January 2020, together with the reports of the Kolkata Municipal Corporation and any exception to them that may be taken. So all earlier calculation was set aside by the earlier division bench, 8th January 2020. So now if you proceed with execution, your execution will be based on the report of the corporation, subject to any exception that might have been taken. So this is now, so what happened, my lord? They filed a writ petition. Kindly come to the order in that writ petition. At page 92. And my lord, the scheme of the Corporation Act, your lordship is aware. My case is a case of reimbursement to them. They are the persons primarily liable to pay to the corporation, even my share. And once they pay their share, this apportionment will only help them to recover it from me. So, my lord, ultimately, this amount, if I have directly paid it to the corporation, even if it is in excess, because they say they have challenged it, saying that you have revised it. So even if it is an excess which has been crystallized and I have paid it for their credit, it is lying to their credit in the corporation account. So they will get benefit of that. Today, if I pay this again to them, it's a question of double payment. So my lord, that is what we had argued. Kindly come to the order of the writ court at page 92. Petitioner is aggrieved by the order dated 27th August 21 passed by the hearing officer, whereby annual valuation has been sought to be revised retrospectively. It has been submitted that the said revision was triggered by the order passed by the Honorable Division Bench of this Court on 8 January 2020. Then, my lord, it appears from the communication of Assessor Collector North dated 16 September 2021. That is the, my lord, I shown. Presently, a sum of rupees 1 crore 51 has been found due and payable by Canara Bank, who happens to be the lessee under the petitioner, and the amount which has been found due and payable by the owner of the premises, that is the petitioner, is 56 lakhs. According to the petitioner, they have already paid the amount on account of property tax for the disputed period, and the corporation do not have the power and the authority to revise the annual valuation in the year 2021 retrospectively for the period such and such. Advocate prays for stay of operation. Learned advocate representing the Canara Bank submits upon instruction that the bank is agreeable to pay the amount on account of property tax as well as surcharge for the disputed period as claimed by the Assessor Collector North in the communication dated 16 September 2021 after adjusting the amount of 19 lakh and odd which has already been paid by the bank to the landlord. It has been submitted that the bank would pay the amount that has been found to be due and payable without prejudice to their rights and contentions. Then, my lord, kindly comes to the next page. Second last paragraph, page 94.
$330 matter. Whose matter is it? Your matter. Both sides are here.
After vacation, something. There is an interim order is there.
It's your appeal.
My appeal. Tanuj Singh is here. This will take time.
Talk to him if you both agree.
Not you can keep.
After vacation.
There's an interim order, my letter has already complied with that. So.
लिखे ना 330 matter. Commercial 18. What is the cause title?
This is Anjani Kumar Lakhotia.
Achha. As jointly requested by learned counsel for the parties, let this matter stand over till after the summer vacation and be listed again on
1 week after launch.
On
16, 17, whenever.
On June 17, 2025. Stop paragraph. The interim order that is in operation, is it limited in time?
No.
No.
Shall continue. The guarantee had to be furnished for 8 crores for stay. Guarantee is furnished.
Shall continue.
Record that.
Shall continue.
Shall continue. And the appeal will, I think the order is there. Because the appeal to hear, appeal hearing itself. Oh, your order is there.
Very well. Huh? You also? Shall continue.
It may retain its position at 3:30. It can be fixed on at 3:30 minutes.
Come back after vacation, we'll see. Yes.
Page 94. Kindly see. Second last paragraph. It will be open for the bank.
34.
94.
Yes.
It will be open for the bank, that is the lessee of the property, to pay the property tax and surcharge which has been raised by the Kolkata Municipal Corporation, and corporation is directed to accept the same without prejudice to the rights and contentions of either of the parties. So this liberty I got in their presence, in their writ petition. Then kindly come to page 95. I'll continue, my lord. It is made clear that if the revised annual valuation of the property tax is ultimately set aside by the court, then the amount that is lying with the Kolkata Municipal Corporation shall be adjusted with the future bills to be raised by the corporation in respect of the said property. So it goes to their benefit. The claim of the petitioner as regards reimbursement of the amount from the lessee on account of property tax dues already paid by the petitioner on behalf of the lessee to the Kolkata Municipal Corporation for the disputed period shall also be taken up for consideration on the next date. Issue of maintainability of the writ petition raised by the respondent is kept open to decide such and such. So, my lord, so this was the order of the writ court. Thereafter, my lord, kindly see the payment was made by us. Page 248. 6th of April 2023. Yes. Kindly see, my lord. We have received the court order for proportionate share of property tax and surcharge payment for the period 1st September 2006 to 30th September 2011 for the area occupied by Canara Bank.
Page 248A আছে দেখো এটা
Oh.
proper.
The typed copy is at 248A. We are hereby submitting demand draft in favor of you as per the details given below. So our first demand draft amount is 99 lakhs, then 27 lakhs, second demand draft 1 crore 26, 21 725. This entire amount which has been assessed on our account.
Page 249 এর হচ্ছে কোথায় রাখলো?
Then, my lord, the corporation has also issued a receipt for that at page 249. Now, thereafter, my lord, they file a general application in the execution proceeding. Kindly have a look at the prayers. It starts at page 96. This is the present round of litigation from which, my lord, the appeal has come. GA number 3 starts at page 96. Well, I shall go through, my lord, some particular pleadings in that application. Kindly come to paragraph 11, page 100. All, my lord, the previous proceedings have been referred. Paragraph 11 refers to the report filed by Kolkata Municipal Corporation. The liability of the judgment debtor with respect to aforesaid period towards municipal rates and taxes was ascertained at 82 lakhs and 68 lakhs, aggregating to 1 crore 51. By the order dated 30th September, the appeal after recording ascertainment of tax and appeal was disposed of. Then, my lord, paragraph 12 refers to the writ petition. Paragraph 13 at page 101 is their ground of exception to that assessment, which is pending adjudication in the writ petition. Then kindly come to paragraph 14.
That writ is still pending?
Yes, writ petition is still pending. Amra ki party noi to. Okay. Paragraph 14, your lordship will see, in view of the subsequent developments and order of the Court of Appeal, present application has been filed to seek enforcement of the judgment and decree. Then, paragraph 15, apart from a sum of rupees 19,81,273 towards reimbursement of municipal tax and surcharge, the judgment debtor has not paid any further amount till date unto the decree holder in spite of several communications. So first is admission 1981, I have already paid earlier. They're saying, ignoring my payment made to corporation in terms of liberty granted by the writ court, allegation is no payment has been made. I am just showing their case. Paragraph 16, my lord, 102. Therefore, they say, direct the judgment debtor to make payment of a sum of rupees 1 crore 6 lakhs 1,500 after adjustment of sum of rupees 19 crore 81 from the original sum of rupees 1 crore 25. That was in the first round of execution. In the tabular statement, this 1 crore 25 was there. 8th January order, everything calculation has to go. Now fresh calculation has come of 1 crore 25. Out of which 19 has already been, you have accepted that it has already been paid. So whatever has been the assessment done, I have paid it. So they ask the executing court to go back to the figure of the original tabular statement, practically ignoring 8th January 2020 order. So my lord, this was their application. Prayer A is also for 1 crore 6 to be paid. Now, my lord, thereafter, your lordship will kindly come to the first order which was passed in this GA3 is at page 145. 27th of February 2024. এটাতে GA3 ডিসপোজ অফ হলো GA3 ডিসপোজ অফ করে তারপরে এটা kindly come to court's view, my lord, from page 149. Paragraph 6. Now, if we look into the other side of this case, we shall find that there is no material on record to show how much amount have been paid by the decree holder to the corporation on behalf of the judgment debtor bank. The quantification made by the decree holder was contested by the judgment debtor by contending that instead of 50% share of municipal tax, decree holder was claiming 2/3 of the share of municipal tax and surcharge which the decree holder could not claim. The record shows that special referee was appointed to get the relevant quantification, but ultimately the same was not accepted, and by order dated 8 January 2020, Honorable Division Bench asked KMC to make an assessment of the respective share. KMC filed a report as per order dated 8 January before the Honorable Division Bench, but the decree holder alleged that in the garb of assessment that they have made revised valuations of property which KMC was not entitled to as per order dated 8 January 2020. However, the division bench by order dated 30th September disposed of the appeal with certain directions. But I have already placed this order. Then kindly come to paragraph 7. Paragraph 7, challenging the report, one separate writ petition was filed by the decree holder by order dated 30th June. Single judge has kept all issues open, further given liberty to bank to pay the property tax and surcharge which have been raised by KMC, and corporation is directed to accept the same without prejudice to the rights and contention of either of the parties. It is also observed that if the revised annual valuation is ultimately set aside, then amount lying with the KMC shall be adjusted with the future bills to be raised by the corporation in respect of the said property. It is also observed that in the aforesaid order that the claim of the petitioner landlord as regards reimbursement of the amount from the lessee bank on account of property tax dues already paid by the petitioner landlord on behalf of the lessee bank, this shall also be taken up. Keeping aside such observation, I would like to say that the allegation that bank was unable to pay municipal tax etc. for quantification comes to an end as soon as KMC, as per direction of the Honorable High Court by order dated such and such, submitted its report quantifying the amount of taxes. Therefore, quantification of the amount of municipal tax and surcharge has been crystallized as the instance of KMC. Now the bank cannot take the plea. It is in the state of confusion as quantification of the amount has not. I have never taken the plea. I have paid that amount. Then, my lord, kindly see. However, it appears that bank has deposited its alleged share of municipal tax and surcharge with KMC without obtaining leave of executing court or the Honorable Division Bench, who asked KMC to file the quantification or assessment as the case may be. But the appeal was already disposed of. I had no occasion to go to the division bench. The decree holder has challenged the quantification in a separate writ proceeding on the ground that the KMC, in the garb of preparing assessment of municipal tax and surcharge in respect, has actually revised the annual valuation of the property, which they cannot do so. In that proceeding, bank has persuaded the Honorable Court on the point whether they can pay the amount as indicated in the report of KMC, and the concerned court gives liberty to the bank to pay the amount subject to certain conditions. There was no condition, simply stated I can pay the entire amount which has been assessed. The steps taken by the bank, my lord, this, my lord, in my respectful submission, my lord, is a bit confusing, my lord. The steps taken by the bank has further complicated the execution process. But I have aided the execution. Has complicated the execution process when it pays the amount to the account of KMC in connection with a proceeding which is totally unconnected with the instant execution process. But even if, my lord, I take it for granted, my lord, there is no KMC proceeding. Even then, out of court, I can pay the amount. Suppose, my lord, the assessment had been done. I am a party to that assessment. I have got a copy of the order of assessment. I can directly pay it to him also, without even coming to the executing court. And he is bound, my lord, thereafter to approach the executing court and say that the decree has been adjusted in part, either in whole or in part. That can be the case, but does not mean that I cannot pay my liability. Then, my lord, kindly see, steps taken by the bank has further complicated the execution based amount in connection with, especially when division bench by its order dated such and such has directed this execution court to proceed with execution proceedings after considering the order of division bench dated 8 January 2020 along with report. And any exception is absolutely unnecessary and attempt to divert the execution process. Therefore, I find merit in the submission of the learned counsel for the decree holder. However, for the purpose of asking the judgment debtor bank to pay the exact amount of money for reimbursement to the petitioner decree holder is directed to submit particulars of the relevant amount which the decree holder actually paid to the KMC in connection with municipal tax on behalf of the judgment debtor. And again, I am left to their mercy to come up with a calculation.
Paragraph 10.
Now, kindly, my lord, kindly come to paragraph 10 from the above. And other material on record, it is pertinent to know how much amount the decree holder actually paid on account of municipal tax and surcharges on behalf of the judgment debtor for the relevant period, and this would assist the court to take the instant proceeding to a logical end. So this exercise was not necessary. Then, my lord, what happened, my lord? Again, they filed a supplementary affidavit with some calculation, my lord. Then, my lord, there is a subsequent order. I had preferred an application for review of this order. That was also dismissed. Now, my lord, this is the order which we are challenging. This is page 192, 22nd of May 2024. So 27th February, finding is that I could not have paid directly to corporation. I have complicated the execution process and they are now directed to give a fresh calculation. They gave a fresh calculation on the basis of a supplementary affidavit. Now this is that order. Lordship has 192. This is order dated 22nd of May 2024. At the onset of the present discussion, I would like to make two short corrections in the order dated 27 February 2024, the order dated 20th September 2016, and the order dated 8 January 2022. In the body of the order dated 27 February should be read as 20th December 2016, and that is fine. Now, paragraph 1.1. By order dated 27 February, the decree holder was directed to inform the court as to how much amount the decree holder actually paid on account of municipal tax and surcharge on behalf of the judgment debtor for the relevant period for the purpose of assisting the court to take the instant proceeding to a logical end. For appraising the court, one supplementary affidavit was affirmed on April 23, 24 has been filed by the decree holder. Learned counsel appearing for the decree holder, Mr. Bose, has drawn the attention of the court to Annexure C at pages 30 to 34 and submitted that the report of the Assessment Collection Department of KMC dated 6th January 2017 shows that municipal tax and surcharge for the entire building were paid from first quarter 95 to fourth quarter 2011. As the entire payment has been made, including the portion under occupation of the judgment debtor, decree holder is entitled to reimbursement for the payment of municipal tax and surcharge in respect of the suit premises till the third quarter 2011. In other words, instant execution proceeding was started for reimbursement of municipal tax and surcharge in connection with the portion occupied by the bank for the period September 6 to August 11. As the said demand details found in Annexure C discloses that there is no due on account of municipal tax and surcharge for the entire building, including portion occupied by the judgment debtor bank, the latter is liable to reimburse the amount paid by the decree holder on behalf of the judgment debtor bank. Mr. Bose has further drawn the attention of this court to the report dated 15 September 21 filed by the Kolkata Municipal Corporation showing the total property tax liability of the judgment debtor bank as per terms of settlement was 1,51,00,000. Learned counsel pointed out such report was prepared by the Kolkata on the basis of the order dated 8th January, wherefrom it will be evident concerned office of the Kolkata has made such report after considering judgment debtor bank's occupied portion in the relevant premises. Therefore, judgment debtor bank should be asked to reimburse the amount of 1,451 in favor of the decree holder after adjustment of the sum which was previously paid to the decree holder by the bank. Then, my lord, after paragraph 4 at 195. After considering the submission and counter submission of the learned counsel of the parties and also taking annexure C of supplementary affidavit as well as report dated 15 September, I find that though the report dated 15 September 21 has specified the amount to be payable by the judgment debtor bank in respect of its occupied portion as per the terms of settlement, there is no specific amount given by the decree holder in the supplementary affidavit showing the exact amount paid by decree holder for the portion occupied by the judgment debtor bank. So even the executing court second time is not satisfied on the basis of the information furnished by them. Unfortunately, one will kindly see from the annexure C, it appears that during the relevant period, that is from 1st September 6 to August 11, decree holder paid municipal taxes and surcharges for the entire building, including portion occupied by the bank. Judgment debtor has admitted its tax liability in respect of occupied portion for the period from 1st September 2006 to 30th September 2011 is to the extent of 1,26 crore. Letter dated 6th April 23 addressed to assessor collector is very much relevant. Then, my lord, that letter has been quoted by which we had submitted the demand drafts. Then para 6. From the above, it is transpired that judgment debtor bank has admitted its tax liability at rupees 1,26 crore for the period from 1st September 2006 to 30th September 2011 for the area occupied by Canara Bank in premises number such and such. It is pertinent to mention here that judgment debtor did not try to ascertain from the Kolkata Municipal Corporation as to whether decree holder paid any amount for municipal tax and surcharge for the portion of the judgment debtor bank or whether municipal tax and surcharge for the entire building relevant period have been paid by the decree holder. Such an inquiry should have been made by the bank, since the decree holder has been consistently claiming that it had paid municipal tax and surcharge for the occupied portion of the bank. The annexure C, this is not part of the division bench order. Division bench says ascertain the tax liability of the occupant. That has been done, 50% I have paid. Annexure C discloses that the contention of decree holder has a certain basis. Therefore, without ascertaining the same and without disclosing the entire matter to the Honorable Coordinate Bench presided over by Justice such and such, the decision to make payment of 1,26 crore to the fund of the corporation at the instance of the judgment debtor not only complicate the issue, but also suffers from defect of multiple payments. So it's an acceptance that it is a case of multiple payment. I have paid my liability. My certain cases, people are hauled up for not making payment. Now that I am hauled up for making payment. Paragraph 7, my lord, in the earlier order of February 27, 2024, this court came to the conclusion that such payment on account of municipal tax and surcharge for the relevant period to the fund of Kolkata was done by the judgment debtor without leave of the Honorable Division Bench dealing with the relevant without leave of the executing court. And the same was done at the risk. But it was not done at the risk, it was on the basis of liberty granted by the court. Para 8, my lord. And my lord, your lordship, will also find when I wanted to make the prayed for the leave to deposit, there was no objection from them. Because this amount will not vanish from the corporation. Amount is for their benefit. Yes. And the interest would have accrued. I had to mitigate my loss, my lord. From the order dated December 20, 2016 of the Honorable Single Judge and order dated January 8, 2020 of the Honorable Division Bench, it is transpired that decree holder is entitled to receive the amount of municipal tax and surcharge in the nature of reimbursement, and that observation of the Honorable Division Bench have reached finality. Therefore, being the executing court, I am constrained to hold that such payment to KMC by judgment debtor without obtaining leave of executing court which dealt with the matter directed, this was also is beyond authority of the judgment debtor bank. Now, this is the issue. Now, my lord,
Paragraph 10.
paragraph 10 is also very important, my lord. 199. Therefore, sorry, 9, as the admitted tax liability of judgment debtor in respect of area occupied by it in the relevant premises for the period is 1 crore 26. This is contrary to corporation assessment. The bank is under, so they are going back to their original tabular statement of 1 crore 26, which has been discarded by the division bench. My lord, executing court in the earlier part of the order finds that the supplementary affidavit does not contain the details. You are asked to give supplementary affidavit to give the exact details. How much of it you have paid for my share? That details has not come. That is the observation of the executing court. Now at paragraph 10. However, astonishingly, in the relevant supplementary affidavit in para 6, it has been averred from the side of the decree holder that unless the judgment debtor is directed to make payment of 67,50,000 along with a sum of rupees 22,41,000 on account of interest upon adjustment of the receipt of sum of bank amounting to 19,81 towards reimbursement, the decree holder shall suffer irreparable loss and injury. It appears, kindly note this, my lord, it appears that the said amount was seriously criticized by the Honorable Division Bench in the earlier proceedings, being not backed by requisite calculation. But unfortunately, the said amount has again been claimed by the decree holder. Well, I thought all this is in my favor. However, as the judgment debtor bank admitted its liability to the extent of 1 crore 26, we do not know where the admission was. For its occupied portion, for the period 1st September 31st hour, I direct the judgment debtor to pay 67,50,000 without the interest to bring the matter to a logical end. So, my lord, I have paid 1 crore 50 in terms of the assessment. If the decree holder is entitled to the interest, it has to take appropriate steps for recovery since it does not whisper about accrual. So, my lord, this is my challenge. My very short question, my lord. Division bench crystallized the right of the parties for the purpose of determination of liability. Corporation passed an order crystallizing the liability. Well, I have paid the liability determined amount to the corporation, which stands to the credit of the decree holder. And for their benefit, if that assessment is set aside on the ground raised by them, the entire amount will be practically theirs. Now, my lord, executing court comes to the conclusion that my deposit is bad. But if I my lord, say this, my lord, even if assuming but not admitting, my deposit is bad, and the learned executing court preferred that I should pay directly to them. Even in that case, I cannot be subjected to double payment. Then I should have been given liberty to withdraw that money from the corporation and pay it. But once that amount has been paid, it stands there to their credit, then I cannot be subjected to this payment again. And if your lordship sees, now their case has to be on the basis of January 8, 2020 order. They cannot go beyond that. What they are now saying that the no demand details would show that they have no dues to the corporation. That is a matter between them and the corporation, which is pending in the writ petition. So because of that issue, the executing court, in my respectful submission, was not required to go in for a further calculation again. Because division bench decided that my calculation or your calculation will not do. Corporation has a statutory obligation to make apportionment of tax liability of the occupier and the owner. Corporation has to discharge that obligation. So corporation has discharged that obligation. You may be dissatisfied. So here, calling first order, even calling for a calculation from my learned friend's client, that was itself beyond the division bench order. That is my respectful submission. So, my lord, these are my submissions that I have discharged my liability under the decree. I should not be made liable for double payment of
The assessment that KMC made pursuant to Justice Shonji Banerjee's division bench order, that assessed only your liability, 50% liability, or their liability?
their liability also.
Liability also.
If your
You
lordship,
paid your portion
I paid my portion.
for the entire period of 11 to 16. No,
That-
sorry,
yes,
6 to 11.
6 to 11.
6
6
to
to 11. If I may just come back, my lord, once to that report. Yes. The table is very clear here. Your lordship will see per year they have done it. At it is at 143.
144 এর নিচে আছে দেখো ট্যাক্স লাইবিলিটিটা
এই যে এইখানে আছে, এইখানে এমপি
হ্যাঁ হ্যাঁ হ্যাঁ
42 level of recorded owner.
নিচে দেখো টোটাল লাইবিলিটি রেকর্ডেড ওনার এইটা
Mr. Bose. Do you say that the bank's share of liability of property tax and surcharge for the relevant period of September 2006 to August 2011 is more than what they have deposited, 1 crore 26 or something? How much have you deposited?
1 crore 26.
1 crore 26. It's more than that. Then if they have deposited it, how could the learned judge say pay again? What is this no leave taken, no leave
I'll tell you,
taken?
Lordship. Well, allow me to address
Yes.
you, Lordship, only on this issue.
Yes.
Lord, kindly first take the division bench judgment of Justice Banerjee. Lord, kindly come to page 83. Lord, this was an appeal that was preferred, my lord, by the bank against orders passed in execution proceedings. Now, what your lordship should be told is that these orders of execution came to be passed in terms of a compromise decree. My lord, it was my suit against the bank for recovery of possession. On a Chapter 13A application, the suit was decreed. Thereafter, terms of settlement was filed.
Terms were filed. I mean, the decree was passed in accordance with the terms.
And no, in appeal, the terms was filed in appeal.
In appeal.
In appeal.
You obtained a decree in 13A.
In 13. So, in appeal, when the terms of settlement was filed, the decree was modified. Now, it all starts from the terms of settlement. Under the terms of settlement, the bank agreed, A, to pay the service tax along with interest, that is one component, for a particular specified period, and also the municipal rates and taxes for on and from the first quarter of 95 to the fourth quarter of 2011, together with interest. Now, my lord, this period, the tax for this period, my lord, me being the person primarily liable, being the owner of the property, had already been paid. So the terms of settlement said that the amount that I have paid, out of that, the portion which belonged or ought to have been the liability of the tenant, that will be ascertained and paid by the tenant, which is the appellant before your lordship, Mr. Shakhushin's client. Similar, this they did not pay. So we enforced the compromise decree in execution proceeding.
That they were to pay to you.
To me.
Under the terms of settlement.
Under the terms of settlement. So I was executing a I would just wish to draw your lordship attention to just to that clause of the terms of settlement. My lord, the terms of settlement starts at page 27. This took us a lot of time before the learned single judge also. Because initially, at the first blush, if one doesn't know these facts, initially it would feel that, first blush that, once paid, why should it be paid once again? Now, my lord, kindly come to page 29. My lord, the settlement starts at page 28. If your lordship kindly takes the trouble of coming to page 29, the typed copy is, your lordship will find it at page 29A. Kindly take from paragraph 3 at page 29. The appellant bank shall pay rent at the rate of such and such, inclusive of maintenance, but exclusively of municipal tax, such as electricity, from 1st of April 2009 to such and such. Then, my lord. Then, my lord, your lordship will kindly turn to clause 4. Then shall pay rent at the rate of 55 rupees per square feet, inclusive of maintenance charges, but exclusive of municipal tax, such as and electricity charges from 1st April 2010 to 31st March 2013. Now, my lord, your lordship will kindly come to paragraph 8. The parties have accepted and reconciled the claim of the Kolkata Municipal Corporation, clause 8, my lord, and commercial surcharge for the period 1st of April 94 to 31st of August 2006 at a sum of rupees such and such, as and by way of full and final settlement. The landlord will have no further claim whatsoever in respect of the opposite claim.
Period.
Your lordship will kindly kindly gives me a moment, but I'll just give you. The difficulty is that the paper book has now come. My markings are all in the stay application, which everything has changed. Parata bolo. Parata bolo nama. If I may just bring your lordship back to para 3 once. In fact, my lord, this has been specifically recorded in the division bench judgment of Justice Banerjee. The division bench presided over Justice Shonji Banerjee at page 83. Lord, kindly take this once, my lord. Page 83.
No, but in the terms he wanted to show us, that they were to pay to you certain sums. That
I tell you, Lordship, what has happened. They retained a portion of the tenancy. So for the portion of the tenancy, the rent was specified. And so far as the tax component and service charge is concerned, they were made into separate slabs. In respect of this period, you will pay so much. In respect of this period, which has already been paid, you will reimburse. So this entire calculation is there in the division bench judgment at page 83, with both parties have accepted. If your Lordship will kindly take page 83 once. This is the division bench judgment of 8th January 2020. My Lord, kindly come to page 84. My Lord, the second paragraph. The two appeals arise out of the orders dated such and such, passed in execution proceeding. There is no dispute as to the entitlement of the respondent lessor, which is my clients. Terms of settlement executed in appeal between the parties clearly provide for the respondent herein being entitled to 50% of the municipal taxes and 100% of the surcharge allowance in respect of the tenanted portion from the period 1st of September 2006 till March 2016. The terms of settlement of August 2016 contemplated that the appellant bank to continue in occupation of the premises in question till 31st of March and provided for lease rent at the rate of such and such per month for the period from such and such at the rate of such and such per square foot, and from the month of April 2009 to March at the rate of such and such. Then this is specified. Then it is undisputed position that by or about 30th September 2011, the appellant bank removed itself from the premises in question, and thus the liability of the bank to pay rent and municipal taxes and surcharge in respect of the leasehold premises was till the end of September 2011. The execution case came to be launched upon the bank not paying the share of municipal taxes and surcharge notwithstanding the terms of settlement dated August 3, 2016. Specifically requiring the bank to pay 50% of the municipal tax and the entirety of the surcharge. Then it appears that there was a previous dispute as to whether there was any service tax which was levied, but that was resolved before the execution and execution was launched, and in the execution proceeding the only dispute was to the quantum that was payable by the appellant bank on account of municipal tax and surcharge. So, well, this was the only dispute in respect of which the appeal was preferred. It is evident from the records that the amount claimed to be due in the tabular statement filed by the respondent herein was not supported by requisite calculations in the affidavit accompanying the tabular statement. A supplementary affidavit came to be filed by the respondent in January, which indicated a different basis. A further supplementary affidavit was filed by the respondent in March 2017, and was further supplementary affidavit gave another figure at the amount due and owing by the appellant herein to the respondent on account of municipal tax and surcharge. For completeness, it is also necessary to record that the executing court appointed
page 88,
yes, madam.
part of that order,
Yes.
this middle paragraph, that puts an end to everything, Mr. Bose.
Middle paragraph.
In view of such provision.
Yes. In view of such provision, the parties are left free. Now, my lord, kindly appreciate this, my lord. This is in terms of, my lord, kindly see the previous paragraph under section 178. Now, my lord, the issue was, how much will they pay to me? The fact that they have a liability to pay to me, it was never in dispute. The appeal was carried. If your lordship will see the previous paragraphs of the initial portion of the recordings in the appeal court, where it is specifically recorded that in terms of the terms of settlement, their liability to pay municipal taxes and surcharges is undisputed. But the quantum that was required to be paid, they disputed that.
Liability was 50% of the property tax,
Correct.
100% of the surcharge for the area under their occupation.
Right.
The corporation, pursuant to this order which you are placing.
Before your lordship comes to the corporation part, my lord, then at that stage, I said that you pay me 100 for service tax and 500 for municipal tax, hypothetically. Now they disputed that figure. Now I was required to file supplementary affidavit before the executing court, which I did, and the executing court could not come to a conclusive finding based on the computation procedure that I had given to the executing court, that this is actually 100 and 500. So that was carried in appeal. An order passed in the executing court based on what I said was due and payable to me was unacceptable by the bank. So they carried those order in execution in appeal. So the appeal court says that what is in dispute is the quantum. Now, in order to arrive at what is the amount payable by them, so it has to be apportioned. I have paid it to the corporation for the entire period. So for the purpose of apportionment, section 178 was invoked. And
no. So are you saying that this money that they paid to the corporation should have been paid to you?
Absolutely. That is what Justice Apurva Sinara has held. Now the money which I have paid to the corporation for that period, corporation, now I'll tell you, Lordship, what corporation did. Now, my lord, here in this order of Justice Sanjeev Banerjee, Justice Banerjee said that very well, since corporation is the expert body, there is a provision called section 178 when a party can apply. That is a provision which is given for a SSE. The self-assessment procedure, SSE can apply to the corporation. He said you all can invoke section 178, and if parties apply, if they apply, then corporation will exercise their authority and ascertain. No authority was given. I'll show your lordship the next order after the report came of the corporation. What corporation did, when we applied to the corporation that for this period, kindly apportion the tax liability of the bank. Corporation took that as a cue, issued notices, and for that period retrospectively reassessed and revised the annual valuation.
That is a different
Right,
aspect.
that's a different issue.
Yes.
Now, what I wish to draw your lordship, in the report that the corporation give, if you now, my lord, allow me to place two more paragraphs from Justice Banerjee's order, then I'll take your lordship to the report filed by the corporation. Now, my lord, kindly come to this. Now, my lord, kindly, if your lordship was showing me the middle paragraph of page 88.
In essence, what you are saying, KMC has been paid twice.
Yes. Twice. That's why, my lord, this is the unusual situation. A bank where his liability is crystallized, except the quantum. That the fact that they were liable to pay the municipal tax and surcharge to me is provided in the division bench order. And if your lordship allows me to place paragraph 88 once, page 88, before page 88, lordship will kindly look at this. Lord, kindly take page 84 of this judgment of Justice Banerjee. Only for the purpose of apportioning the amount or the quantum to be paid by them, liberty was given to the parties to approach the corporation. We did approach the corporation. And corporation assessed their liability during that period at 1,21 lakhs. So the amount that they have already paid to me prior to the appeal in execution, that we said you deduct that and you pay me the balance.
19 lakhs.
Yes, 19 lakhs, they pay me the balance, which came to 67 lakh 50,000 so far as the municipal tax is concerned. That is the amount you were required to pay. What they did, I'll tell you, Lordship, my lord, when this order of corporation came, after they ascertained the liability, and corporation revised the valuation. So, if your lordship will, there is a subsequent division bench judgment Based on Justice Sanjeev Banerjee's judgment, corporation was directed to ascertain. We approached, corporation filed a report before the division bench. Appeal was pending. My lord, allow me to place that paragraph. Then it will become clear. My lord, may I first complete the Justice Banerjee's judgment? Your Lordship, we were at page 88. In view of such provision, which is section 178 of the Kolkata Municipal Corporation Act, my lord, kindly take the previous paragraph, middle of the previous paragraph. In such context, yes, in such context, the appellant refers to section 178 of the Kolkata Municipal Corporation Act and says that subsection 6 therefore permits both an owner and a lessee in respect of any premises to apply to the corporation for the corporation to indicate the apportionment share of the relevant party regarding the municipal rates and taxes. In view of such provision, the parties are left free to apply to the corporation for the corporation to determine what would be the apportionment share of municipal tax and surcharge for the area at the premises under the occupation of the appellant herein during the period from April 2006 to September 2011. Upon such determination being arrived at, the appellant herein will be liable to pay 50% of the municipal tax and the full complement of the surcharge that is indicated by the corporation, subject to the right that both the appellant and the corporation respondent may have to apply to the corporation for correction of any error perceived to have been made in the relevant determination. Let this appeal now appear next. Sorry. Now kindly, my lord, take the next order. After the report came, kindly take the order at page 9. This is post the report of the municipal corporation. The Kolkata Municipal Corporation has filed 2 reports by way of an affidavit and a supplementary affidavit in terms of the order of the division bench of 8 January. Mr. Such and Such appearing for the respondent submits that the corporation has transgressed the area demarcated to it by this order. It was also required to determine the respective shares of the parties in the municipal tax payable. Sorry. It was also required to determine the respective shares of the parties in the municipal tax payable in respect of the subject property. It was not entrusted with making a revised valuation of the premises. He says the valuation aspect will be taken up by his client in an appropriate jurisdiction, which was my writ petition. Be that as it may, subject to the decree being modified in appeal remains unexecuted. We admit the appeal, dispense with formalities. Thereafter, my lord, with the direction, the respondent will be at liberty to take out a fresh application before the executing court to execute the decree of 31st July, which is subsequently modified by the decree.
Yes, this decree of 31st July 2008 was modified by
appeal courts.
Appeal court.
Previous.
4th August 2010.
Yes. Yes. Well, these are all orders of orders of 2021 after 12 years. That is after execution, interlocutory orders in execution, appeals.
While executing court will take into account order.
Now your lordship will see. So I am giving liberty to now go based on the report to go before the executing court, and because my decree has to be satisfied, so I go before the executing court I take the report. So from the report, what I take is the quantum ascertained.
Can you show us anything which is on record which will demonstrate
Yes.
that for the relevant period,
Yes.
2006 to 2011,
Yes, yes.
you actually paid the entire property tax and surcharge
Don't
dues?
use certificate. That was there before the executing code, which is recorded, which is there, my lord, at page 193, recorded at page
In
193.
respect of the entire premises?
Yes. It is also not corporation's case. Corporation is now saying that I have retrospectively revised the manual.
That's different.
So now what has happened is, now what they paid is the revised valuation. So it's your choice. That's why Justice Amrita Sinha's order in the writ court, we raised the objection, said that without prejudice to their rights, if they want to pay, it's their problem. How are you concerned?
Yes, but the revised valuation will also have an element of original valuation. So anyway, corporation has received much more than it is entitled to.
No, my lord,
That has to be decided.
if they have chosen to pay to an authority in excess of their liability, so it is for them.
But that cannot be decided here.
Very well. When? Tomorrow?
Wednesday, if your lordship is, if it's not inconvenient, my lord.
Problem is, tomorrow some other matter will get inside.
That's what I
The
was also
problem.
thinking. Well, if it can be concluded, but since your lordship
Please do it tomorrow. Because Wednesday, two other appeals have been fixed. It won't be heard. And if you don't conclude this side of the vacation, we'll forget everything.
No, we will. I'm a little under the weather. That's why I was just.
If you are taking tomorrow off, no problem.
In the event, my lord,
In the event you are not here in court, somebody should mention. On health ground, we never.
No. I will try. Man, I'll be here. Man, I'll certainly be here. My lord, I was respectfully submitting if it could be in the second half tomorrow.
কালকে কখন হবে?
কালটা কখন হয় না এটা?
First appellate side হবে.
কাল তো Tuesday.
Oh, it won't be earlier than the second half, if at all. And if you sneeze, don't sneeze out to your right. Mr. Chakushen, the senior advocate, completes his submission on behalf of the appellant. Paragraph, Mr. Moinak Bose, the senior advocate representing the respondent, begins his argument but does not conclude. Paragraph.
Will it, comment to your lordship, if 3 o'clock or
Already time fixed tomorrow. We can't fix all. In a day, we can fix one matter at a particular time. List the matter once again, কালকে ডেট দিয়ে দাও। শোনো, একটাই জিনিস করো, কালকে টপিক কিছু বলিনি তো? As the first item under the heading appeals from orders.
May I be allowed to mention one matter, my lord? Item number 19, my lord, I could not reach before your lordship.
19 টাও করো না, dismiss, not today করে রেখে দাও।
March.